Good morning, and thank you for coming to the Policy Committee meeting of the board. If anyone would like to make comments, or if we have community come in after, we can have them make comments at the end of the meeting. I'll pass it over to Megan.
Thank you, and good morning again. For the purpose of the record, since we are recording this meeting, I'm Megan Schaefer, the Senior Director of Policy, Personnel, and School Programs, and I'm taking over for the former Assistant Superintendent, Dr. Kelly. So I ask you to please be patient with me today as we move through this. There's some items that are in transition, and I will be deferring to Ken Roos to guide us through some of those topics. So first on the agenda is an item that's up for first reading, which we did, the board did approve this through a first and second reading early in 2013. I believe it was January and February. And since that time, we have proposed some additional language reflecting some concerns or feedback around volunteers. So I'd like to ask Mr. Roos to speak to that.
Thank you. This is not a major change, but this was a refinement that the committee did ask be done to the, as far as requiring background checks of what we call screen volunteers. And these are basically volunteers who are chaperoning overnight trips and regular volunteers who aren't parents or guardians of students in a class. So basically this is just a kind of a carve out for them to require that they have background checks before they serve those functions. That's really the only change here.
I did have a question. I know background checks take some time. So how will we logistically work that in so that parent volunteers and other guardians can participate?
Well, I think it's going to begin with making sure that people are noticed about the requirement, and probably well before the school year begins, we want to make sure that our parent community is aware of this additional requirement. So there is a delay for sure in terms of the processing of those clearances, but so I think we just need to make sure that we're out in front of that with appropriate notice, and we'll do what we can to facilitate that by, making forms available, making sure that the process itself is explained to parents, and making sure that that is something, to the extent that it stands in policy, that we are enforcing consistently.
And are we covering the cost, or are parents and guardians responsible for the cost?
There's no provision for the district to cover the cost.
Okay, so parents and guardians need to be aware that there is I know with teacher education, we have it laid out in detail. So with ARs, I'm sure we need to think that through some.
Right. Very good point.
I think we usually have, if it's a hardship for a family, then I think the principal and HSA is able.
Okay. Next on our agenda are a few administrative regulations, which for the most part are minor revisions. These are standing administrative regulations, and so they're not new. They've been revised. And the first one on the agenda is 134A, and I'd like to ask George Fraser to briefly tell us what the proposed change is.
Good morning. There was a sentence in 134A that spoke to us providing Google Apps for Education accounts to high school students. We removed the words high school so that we could provide Google Apps for Education accounts to middle school students, which we began doing this week with an opt-in for parents.
George, will students be able to use those as just regular email accounts now, or will it only be in order to register middle school students to register them to use Google Apps?
It's a regular.
Okay, so they can use that as their personal email through
It is.
through 12th grade.
It is.
Okay.
It is.
Thank you.
Any other questions? All right. Thank you, George.
Thank you.
Our next administrative regulation relates to students' rights and responsibilities, and I'd like to ask Mr. Roos to speak to that.
Thank you. This simply makes permanent the desires of the policy committee and the board to impose what's basically a permanent moratorium on the idea that student athletes can be suspended for purely off-campus infractions of the drug and alcohol policy. And that, as I said, you had passed this as a moratorium last year, and the board had upheld it for the full year. Now this just makes it permanent going forward.
We've discussed this at regular meetings as well, correct? Because we've discussed this quite a bit in policy, and it's the result of changes in the larger landscape. So I just want to make sure, since we're being...
Correct. The genesis of this was some decisions out of New Jersey that basically called into question a school district's ability to discipline a student athlete for what was purely off-campus conduct. It was discussed at length here with the help of the athletic directors. It was announced at the board meeting. I don't remember if there was any real general discussion about it, but the public and the board were made aware of what the board, and there was no objection to it. And now this just makes it permanent.
So then, does this then prohibit a coach from punishing a student for off-campus?
This prohibits a coach from outright suspending a student, or it no longer means that a student who uses drugs or alcohol off campus, unrelated to school, this means they're no longer systematically suspended pursuant to the policy. As far as the circumstances under which a coach could perhaps not play the student for a half or a game, or not start the student, that's still going to be to some extent within the coach's discretion, but they're not going to be allowed to suspend them. And they're not going to be allowed to do the functional equivalent of suspending them either.
So then coaches who have a no tolerance policy for use of drugs or alcohol, period, can no longer have that in their team rules?
Not per se. They can't say, if you use drugs or alcohol, you're going to be kicked off the team or suspended. They can't do that.
Okay. Might be important to make sure that there's an education piece with the coaches on this.
We definitely need to do a training piece on this to make sure that the coaches know. It is knowledgeable. We always have a turnover in coaches, and as you know, many of our coaches aren't full-time employees of the district. No, it just wasn't on.
Any other questions? Okay. Our next AR is again also something I will turn over to Ken to give us some further context to, but it's related to the procedure for the administration of student records.
What is being proposed here is an amendment to the district's what's known as a FERPA letter. FERPA is short for Family Educational Rights and Privacy Act, also sometimes called the Buckley Amendment. It's really the law that says that student records are confidential, and that and it also requires school districts to maintain certain records for certain periods of. Actually, state law requires school records to be maintained for certain periods of time. There's a lot of there's no clear-cut guidance as far as how long testing protocols need to be maintained by school districts. There's standards that are established by the Americans, I'm going to get the name of this organization wrong. It's basically the umbrella group for school psychologists and for psychologists as to how long testing protocols for nationally normed standardized tests have to be kept. The district has had a practice of saying to their psychologists they need only be kept for a year. The professional association standards are a little different. So what this basically says is, we're going to tell you, we're going to say in our administrative regulations from time to time what that provision is, but in the actual notice that goes to families, it's basically saying that testing protocols and other raw data from psychological testing is just going to be kept in accordance with regulations, as opposed to it's going to be destroyed after a year. Some psychologists don't, they just simply, I mean, they don't do it. They want to defer to the professional standards, so we don't want to have something in place that's not actually happening.
Just a minor point on number 2, page 2. It looks like you've deleted the Y and U. Sorry.
Yes, you're right. I caught that this morning, so.
Oh, one other change at the end. And this has to do with the very end, the use of photographic images. This just simply gives parents the opportunity, it's how they basically state if they don't want their students' photographic image used by the district, for example, on its website or things like that, or Facebook page. This gives a little more precise information about how you're supposed to notify the district about that.
I believe this was Doug Young discussed this also at an ISC meeting. The photographic piece, and I can't remember the date, but it was discussed at the meeting.
How long do they keep the results of their, in terms of, how long do they keep it?
Testing protocols?
Yeah.
It's my understanding, it varies from psychologist to psychologist, that some of them only keep it for a year, which is all the district requires, and some just have a professional habit of hanging on to it a little bit longer.
A little bit longer or forever? I mean, do we require that it be destroyed when the student is no longer in the school, or I mean, can we require that it be destroyed at some point?
We can do that. It's a little bit tricky because sometimes we also use private psychologists. This wouldn't just apply to school district psychologists. This would also apply to contracted services who may feel bound by professional association standards. So this is still something that's being reviewed. In fact, there's actually a meeting of special education and pupil service directors going on in my office actually right now, where this topic is being discussed to try to get the best practices for all school districts. It's not just for that purpose, but that's one of the topics on their agenda. So it's basically still being refined, but we didn't want the FERPA notice to be inaccurate. That's why we didn't want it to just say a year, and it turned out not to be a year.
Is there a date that, in terms of the photographic images at the end of the document, it says that you must indicate in writing by blank?
No, you can do it at any time. If you decide in the middle of your child's high school career that you no longer want the pictures, you just simply send in the notice. So there's no deadline.
So then we should probably remove the word by?
In the new language.
Oh, yes, we should take out the by and the blank.
Okay.
Any other questions about those changes? All right, our next topic on the agenda is a discussion concerning Administrative Regulation 206 relative to assignment of pupils within the district. And again, Mr. Roos is going to provide us with some context to this regulation.
Many people are familiar with the chronology of this, but I'll just review it. It's AR 206. Oh no, it's the right. No, and I'll explain why. It's really not on the table for discussion, but this committee had asked for an update about this. Back in December of 2006, the Administrative Regulation 206, this is the regulation dealing with assignment of pupils within the district or establishing attendance areas. Back in 2006, there was a high school choice area boundaries. High school choice area boundaries were established. In January of 2009, the board approved the changes to the high school choice area. Regulation 206, however, was never formally amended. The boundaries were adopted by resolution of the board. They were posted on the website, but Regulation 206, which contains the detailed boundaries are from this street going up to this street over here, then 90 degrees over to that street, all those very technical descriptions of the attendance boundaries, they were never changed, and it was determined not to change them until the court challenges were finally over and done with, which finally did occur. In June, there was Dr. McGinley laid out the timeline for the discussion and decisions regarding proposed expansion of the school choice area. That would require basically another revision of Regulation 206 to indicate what the new choice areas, if there are any changes to it, would be. And that vote's going to be in November 18th. So as far as the policy committee is concerned, there's no, it doesn't seem to make sense to go back and change the regulation to say what, especially since school's already started. It doesn't make any sense to go back and change Regulation 206 to memorialize what happened in 2009 until after a vote takes place in November of 2013, which may or may not change that. In other words, don't do it twice when there's no impact, there's no practical impact of not doing it between now and November because the boundaries are already established and school year's already started.
So we're going to have a discussion of this or an update of this?
Well, I think that really was the update. We have prepared, we did, I guess 3 years ago, prepare the AR to meet our current practices with our current high school feeder areas. And again, we never brought it back to the policy committee because we were in litigation over a period of years around the issue. And then, quite frankly, you know, it kind of got set aside as we were involved with all the technology policies, and we ran through it, and we never brought it back. So, at this point, if the policy committee wanted us to come back and present the AR that we've been following since redistricting occurred in January of 2009, we could do that. But it seems to be probably a waste of everyone's time to do it now, when we have this other decision that's going to be made in November. And if the decision in November is to expand choice, then the AR that was put in place in 2006 is the AR that would be in place if the board takes that action.
It would be helpful, I think, if you clarify what an AR is vis-a-vis what the
Sure.
Board policy is, because
Sure.
it's not that we haven't been acting within the bounds of our current policies. The AR is not the policy. The AR is the update that explains the details. But
Right.
the district has been following the policies established by the board vote.
Yeah, exactly. It's
So-
the board takes action by policy and by board resolution. The policy 206 basically says there's going to be attendance areas established, and it's got other things besides attendance areas, but that's predominantly it. The board resolution that took place in January of 2009 is what officially established the attendance areas. The administrative regulation is simply an administrative tool for the administration, to look at so that it can implement whatever the board policy and the board direction is. In this case, though, the AR 206 on attendance areas was basically a dead document because it wasn't what was being followed. It was being followed was the board resolution.
So if in November we change the policy by resolution,
The attendance
the AR
areas,
that
you mean
that
the
exists.
choice area.
Right.
If you change the choice
Correct.
area by resolution,
Then we don't have to change this, the AR can just continue, it would be this intact.
correct. If the, yes, if the proposed expansion of the choice area is passed in November, the AR that was passed in December of 2006 now becomes accurately would reflect the wishes of the board.
Are there any other questions or additional clarification we can provide? Okay. Will we move on? Okay. Next for discussion is policy, as distinguished from an AR, 007, which relates to board meetings. And there were some proposed revisions to this policy, which I will, again, thank you very much, Mr. Roos, defer to him to explain those details.
This is an amendment. These are what I would characterize these as cleanup amendments to your policy to bring the policy in line with both current law and current board practice. The first changes occur on page 4, which basically says that a video recording of a public meeting takes out the language that says it's not a public record available for inspection and copying, because according to Right to Know, it is. As far as the changes to the editing, the video recording, this was fine-tuned to basically make it more clear under what circumstances, and they are rare, it has happened, but they are rare, the circumstances under which a board videotape would be edited for rebroadcasting. In all cases, the original board meeting, unedited, would be maintained for someone to view. This is just what would be rebroadcast by the district itself.
And we had this situation last year after parent testimony at a particular board meeting.
A parent inadvertently revealed confidential information about themselves, and they actually agreed and consented to having their comments edited out of the rebroadcast to preserve their child's confidentiality. As far as the other changes on page 5, it spells out that if there's a litigation hold, if there's litigation involving something that took place at the board meeting, that the video recording will be maintained. And then on the last page, actually the next section dealing with if there's video recording by the news media or other members of the public, this has just been updated again to reflect current board practice and new technology. Back when these provisions were passed, basically somebody from the public videotaping a meeting would come in with a tripod and a big camera and whatever, and this was just to kind of basically make sure that was done in an orderly way. That's not the case anymore. Now it's very easy to come in and video record a meeting with something that's very unobtrusive and non-disruptive, so this basically takes out all of these steps that were requested people to follow if they were going to video record a meeting. They're no longer necessary. They're no longer, and I don't believe, honestly, I don't believe they're no longer enforceable. And truthfully, you didn't enforce them anyway, because for all the reasons I just said. So we're just taking it out because it doesn't really apply anymore. And I believe that's it.
I did have a question. When we make the decision or see it necessary to edit the video from board proceedings, what's the procedure for that? And it's in the case where the parent revealed confidential information, they were consulted, but I want to know how we make that decision in terms of what gets edited and then what gets potentially rebroadcast.
Well, a concern can come from anyone. A concern can come from the speaker themselves. The concern can be raised by whoever the speaker was talking about. The concern can be raised by board member, administrator, or me. And once that concern's been raised, the practice is you then go to the speaker first, whoever made the comments, to make sure that to explain why the recommendation is being made, going to be made for an editing, and to see what their position is on it. And frequently, we find the speaker actually joins in the request. or they, for whatever reason, they didn't realize or thought better of the fact that what they said was going to be now rebroadcast. They just didn't completely appreciate the fact that this is going to be broadcast, this is going to be on the district's website in a podcast, that this could be viewed by, conceivably anybody in the school community, including, other students, people that know. So once that decision's been made, then administration reaches out to the board, usually through the board president, and then the board president, and a lot of this is time permitting, because this can be very time sensitive, reaches out to the board president then reaches out to other board members, a consensus is obtained, and then the editing is done. And when the editing is done, what happens is there's a little banner that goes to the bottom of the broadcast that says, portion edited due to, pursuant to board policy. So if somebody was at the meeting and they're watching it and they're saying, wait a minute, what happened? I thought there was something else that happened here. They can see that little banner going at the bottom that says that that portion was edited. So it's clear that there wasn't editing done. It's just not something that goes unacknowledged.
I would also add, in case, I don't know that I heard you say that, but it is acting with the advice of counsel as well in terms of doing the editing process. That's actually articulated in the procedure.
Yeah, I have a couple of questions, although not related to that, and I apologize because I'm reading through this quickly right now, so I'm not sure if I just missed it, but the participation by remote communication device, is this new? It's not redlined, so is that the same as it was before?
Yes.
So there's been no change on that?
No change since
Okay.
2007.
So is it clear, is the person who's participating remotely, can they vote?
Yes.
They can, okay.
Yes, they can vote. Their vote counts. That's the whole, that's the reason why this is in here, is to allow for that person to vote. Otherwise,
I'm
I mean,
just
they
not
could.
aware of that
Yeah.
having happened recently, so I was just trying to clarify that. Okay,
It doesn't happen very often.
okay, and then
I think the time that we would want to be able to do that is if we were otherwise not have a quorum to conduct business of
Right.
the district. Hopefully,
that's fine, I just was trying to clarify that.
I just don't want everyone to take advantage of it by just calling in.
The thought had crossed my mind, no. So unless we use Skype, in which case we can't, come to a meeting. Anyway, the agendas on the board meetings, which are, again, not redlined, so haven't changed. I just have a question about that. The agenda is outlined, on page 1A2. It says what the sort of order of the agendas are. Those are for business meetings, not education meetings, is that correct?
Correct.
So the education meetings don't have a prescribed agenda?
Correct.
And what is the reason for that?
It,
Let me ask the question a different way. I have a different question. It has been very confusing for members of the public that at the business meetings, we have an ability to have audience recognition on an agenda item at the beginning, and then at the end, we have audience recognition on any, and then the education meetings don't run that way. And I think it's confusing to some people because they come and they expect to be able to, they have a sense of how it works and they expect to be able to comment, and then it's different. And I'm just wondering if it makes sense to just
Well,
carry.
I mean, the Education Committee meeting is a meeting that's informational for the board and for the community. So the tradition has been that comments are allowed at the end of the presentations and board discussion. But the comments are about the items that had been discussed, and they're not. There's not an open forum the way there is at a business committee meeting. So, as you know from your experience on the board, at the end of the business committee meeting, people can come and comment on anything at all having to do with the district, sometimes things that have nothing to do with the district. But there is that open opportunity to comment. At the only difference at the end of the education committee meeting is that the comments are limited to the subjects that had been discussed that night. So if we're
Okay.
discussing Keystone exams, then
Right.
comment on Keystone exams, but you're not there to comment on, recess aids or something like that.
Right, I'm not concerned with necessarily changing, I'm trying to make it
Right.
easier for people to have an understanding of what it
Right.
is. Although I have to say that Ms. LaPera had been in the process of preparing a sort of document that could be given to people and put on the website that sort of explain these things, and maybe that's just the best way to go
Right.
about it. I just wanted to raise that issue because it had come up a number of times.
I mean, the only substantive difference is that there's no comment period at the beginning, so people
Right.
can't come to the mic at an education committee meeting and say, I see that, Keystone exams are on the agenda, I want to talk about that first.
Right.
We get to talk about that first, the administration gets to talk about it first, and then people get to comment at the end, after the board has had some discussion. So that doesn't exist at the beginning, and then the comments at the end are limited to the things that have been discussed at that meeting. But there is an opportunity to comment, and
Right.
we have followed the same rules about 3 minutes and sign up and
Right.
those kinds of things that we do at the business committee meetings.
But I guess building on Melissa's point, I mean, should we add a paragraph maybe?
Marissa, can you use your mic?
Should we maybe add a paragraph for the education committee meetings just to spell that out? I don't know if it's necessary or not, but, because in the business meetings it says, it's number 7, audience recognition.
I mean, you couldn't,
And
if you were
for-
interested, you couldn't look this up on here. That's why I was saying potentially you.
There is on page 7, under committee meetings, it does talk about public comment at committee meetings.
Okay, so
But if you're right, if somebody was
I'm
just
just trying to
looking,
make it
if
easier for
somebody was
somebody to
just.
figure out what
Exactly.
is going on if they want to make public comment, that's all.
It makes sense, or otherwise, I can see where somebody would just be looking at the education committee section of the agenda and not realize there's another section on committee that also
Yeah.
applies. That,
But maybe just a sentence saying, see, whatever we're in here, Roman numeral something, letter I, for more information or something.
okay, we can add a cross-reference there. Sure.
I had a question. I'm sorry, Diane. The video recording, page 5, after broadcast, 5G. And I asked you this privately also. After broadcast, the recording, unless there's been a legal hold, could be re-recorded over. How often does that happen?
I checked with our videographer, and Mr. Fraser may want to weigh in on this as well, but it's my understanding that we do not re-record over the board meeting video, that it's maintained for a period of 10 years currently. Is that correct?
Yes, I believe that's accurate. It's 10 years.
Thank you.
So should it reflect that's what we're doing then? In other words,
I mean, it's permissive. It says it may be recorded over. This basically says that, this gives you the ability, the flexibility, if you don't want to keep it
but
for
I
10 years.
don't,
Well, I think
But I
recorded
think
over
we're
is
trying-
old language too.
yeah,
so
I feel like we should keep
be explicit and just
the actual
explain
recording of the meetings
will
for
be-
a period of time,
yeah.
whatever that is we decide as, but it seems like we should have the meetings,
That's fine.
Okay.
We can change that
I
to
mean,
simply
if we
say.
just, after the first word of district, instead of saying may be recorded, just say will be maintained for a period of 10 years.
Yeah, something, that would be.
That's our current practice, and
Okay. I mean, what this is really trying to say is, we're not going to, if there's a legal hold, we're not going to record over it. So
But
one other way to
otherwise-
say it would simply be, whenever a legal hold has been implemented with respect to a recording, the recording will not be recorded over.
except we don't record over things.
We don't record
digitally.
over.
Or not be,
I
or
understand.
will not be
Maintained.
destroyed.
Destroyed, not
Will
be
be,
destroyed.
but if you want to put the 10 years.
I think I understand that you're trying to get the legal aspect of it in there, but it makes it seem like then if there's not a legal hold, we're destroying, you know, so.
I'd really like to know in my retirement that I have at least 10 years to watch all those videos.
10 years it is.
So we could say even if it's, you know, if there's a legal hold, we'll hold it longer than 10 years. You know, I don't know why you would do that. But
Again,
I'm
maybe
not sure.
two separate, I think we're dealing with two separate things.
We
One
are.
is that we want to ensure that when there's a legal
Right.
action, these will be maintained, but the other is that as practice, we might as well say as policy, we maintain them. Again, in my scholarly hat, scholars actually sometimes do watch these and do content analyses of who speaks with respect to gender, something it might compare our school district to some other, so it's nice to have that as an archive.
How about this? This covers everybody. How about saying, while it is the current practice and desire of the board to maintain board meetings for at least 10 years, under no circumstances will they be destroyed if there's a legal hold? Or, yeah. All right, okay, all right. And that way, if somebody accidentally destroyed it, you guys need to see who has the overt violation.
Diane?
Ken, can you say that again?
Yeah.
You turned off your mic. Accident.
Under, while it is the current desire and practice of the, what is the current intent of the board that board meetings, that recordings of board meetings be maintained for at least 10 years. Under no circumstances will a recording be altered or destroyed when a legal hold has been implemented with respect to the recording.
I'm sorry, I'm not an attorney, so I know that, but it makes it sound like somehow we're gonna go destroy, or it just makes it sound like that we can. I think what we're trying to say is, we want it to be board policy that we will not alter or destroy, you know, the recording of the meetings.
About the board directs the administration to maintain recordings of board meetings for at least 10 years.
I like that, thank
Okay.
you.
Furthermore, if there's a
Furthermore,
litiga-
you can have your furthermore.
Furthermore, if there's a litigation hold, it's got to be even longer.
It could be even longer, excellent, thanks.
And technology-wise, we can do that, right?
Yes, and that's similar to what we do with email presently. We maintain email for 7 years, and if there's a litigation hold, we will maintain it longer. So it's in concert with that same concept with what we do with email.
I think also that wording acknowledges that if inadvertently the videographer erases something, you know, that wording gives us some wiggle room that we're not kind of, because that could happen. There's human error always.
I will add the cross-reference on page 1, and then I will add that language to F. Or any other changes?
I have a couple questions too. Again, because since it was up before us, I just looked at the whole thing, not just the red line, so. Under C number 1, it's on page 2, under quorum. It says, quorum shall be 5 or more school members, blah, blah, public legislation. No business meeting shall be transacted at the meeting without a quorum, but the directors at such a meeting may adjourn to another time. Why is that? I mean, it seems like we're stating the obvious, and 2, if there's more to it than that, then somehow I feel like I mean, is it because you don't have enough to, well, we never vote to adjourn a meeting anyway, but.
No, okay, and you're right, I mean, I guess it is kind of a common sense, but this is a explicit statement of what happens when you don't have a quorum. Okay, we don't have a quorum, all right, well, what can we do? Can we talk? Can we do this? Can we do anything? And the answer is, really, all you can do is vote to pick a new time, to adjourn to a specific time. This isn't just voting to adjourn the meeting, this is voting to adjourn it to a specific time. I can say that, we can say to adjourn to another
I
and
see.
specific time.
Oh, I see what you're saying. So this is, the one thing that they are allowed to vote on is when the next meeting is going to be.
So if you added.
And date and time.
Yeah, so if it said may vote to adjourn to another time, maybe that would be more clear.
Directors at such a meeting may
Vote.
vote
To adjourn.
to adjourn to.
May vote to adjourn and set a new time or, you know, yeah, something that makes that a little more clear. I read that just,
Fine,
yeah.
understood.
On page 3, E, number F, the names of all citizens who officially participated in the public participation and the subject of their participation. If I'm not mistaken, we list who spoke, but we don't list what they said.
Yeah, we don't.
So either we take it out because we don't do it, or we leave it in and we start doing it.
I'll look. It's not a detailed description.
No,
could
but it
simply
doesn't
be-
even say spoke to the budget or spoke to the change in textbooks.
Okay,
It's-
well, it needs to do that because the sunshine law requires it.
Okay, so that,
All right, so that's change of practice for us then. The policy
But
is right.
but I can work with Denise to make sure that it need not say anything more than, Megan Schaefer spoke about policy 206, period.
right. Under notice, and I thought we had changed this, but I'm not sure that we did. It's, and let me just look. Notice. So the fourth line down in the beginning of that paragraph that starts with the word notice, on the bottom of page 3. Notice of all special meetings shall be given by publication and posting at least 24 hours prior to the time of the meeting, except that there were two concerns with that. Number one, requiring posting by publication. Our local publications don't come out every day, so if it were Monday and we needed a meeting Tuesday night, say the Mainline Times or Patch doesn't come out till later in the week, or they update it online, but
They
not.
don't do it every day.
Yeah, but they don't do it every day. And then and to put a post like this in something like the Inquirer is, one, expensive, and two, will not reach very unlikely to reach our citizens anyway. So I think, given the nature of communication these days, locking us into announcing in a publication in the case of an emergency meeting may not be such a great idea. Finding another way that is more, more likely to reach our community. I don't know if the township would allow us to publish on their website, or whether we just publish on our website, or whether we require that our school listserv send out. I don't want to exclude anybody in the community from getting notice, but requiring us to put it in a newspaper really doesn't make sense.
You have very cogently and comprehensively summarized many other people's major objections to this part of the law, which is, many people feel is very archaic and is no longer out of date. It's completely out of date and it's very impractical.
Is this code?
This is required by the Sunshine Act. This is right out of the Sunshine Law.
Okay.
And you are, like I said, you're right there with many people who have come forward and said it's time to change this law. It doesn't make sense anymore. You're making us pay money to put ads in a paper that nobody's going to read, when there's 50 other ways to do this better. And unfortunately, the legislature hasn't. I'm not, I mean to editorialize here, but the legislature hasn't
Caught up with it yet.
caught up with that yet.
Okay. And then my last question is page 5. And it has to do with the notification 24 hours in advance. For example, I walked into this meeting not knowing that this meeting was going to be televised. So I think at the very least the board should be notified if the board is going to televise a meeting.
I thought I was directed to make sure that any meetings that contained any discussion of anything connected to high school enrollment, that they were all recorded and televised. I thought it was a direction I got from the board in the spring.
Okay, I don't remember that, and even if that is the case,
Okay.
which
Yeah.
I don't doubt that it is, you know, if board, maybe I wasn't at the meeting where that was expressed to
Right.
you, and so I never knew.
Okay.
So, you know, I just think it's good practice that if we're going to record a meeting, the board should know in advance. We know in advance about the
Right.
evening, you know, the
evening meetings,
you know,
sure.
the legislative and
Okay.
education meetings, but
I can make sure that that happens in general,
Yeah.
not just about this set of meetings as well.
Yeah, that would be very helpful. And secondly, I don't know that we need to require people, but I think when possible, notification in advance would be appreciated. So if someone intends to come and videotape a board meeting for their own use, while I don't think we necessarily can require them, because it's so easy just to lift your iPhone up or your smartphone up and take a video, but when possible, to notify the board in advance, I think that would be helpful. I don't know how others feel.
Well, that's on the next
Bottom of page
6.
5, on to page 6, number 2.
Okay.
I think.
So could we put something in there that says notification would be
Appreciated, but not required.
Yeah.
I guess, I
as a
feel,
courtesy to the board?
I feel like we should assume that all public meetings are potentially being recorded. I mean, the technology today is such that, I think that would be the assumption, but I mean, to say that we would appreciate being notified, I guess it's fine, but I think it suggests that, I think we should just assume we're being recorded. I don't know.
Well, we know we're being recorded by our own.
No,
But I think maybe it's a matter of just asking at the beginning of the meeting. I don't know. And I'm not falling on my sword on this one. I mean, this is not something I feel particularly strong about. I just think as a matter of courtesy, if you're going to, I mean, it used to be illegal to tape somebody without their knowledge. Now, I assume that that's no longer the case, but,
Well,
I mean,
That's not in a public setting. People cannot come and bring a video recorded to this meeting and then position themselves next to people in the audience who are having a private conversation and use their recording to record their conversation. They still can't do that. But any proceeding that is open for the public, there's an absolute entitlement.
But given that
to be
people
allowed.
can't filter out that the person next to them says, oh, by the way, my husband and I are splitting up, it would be a courtesy to citizens to know that people are recording the meeting.
and anybody who has watched their kid's video of a game will hear the commentary from the person sitting next to them on the officiating, on the quality of play, on whatever.
The coach's decisions.
The coach's decisions. So that's a good way of thinking of it,
I
Chris.
guess if we make it clear in here that we would appreciate that so that other citizens would know that they were being
Yeah.
taped, that would be
So
fine.
if it said as a courtesy to other citizens attending the meeting, individuals recording the meeting are encouraged
Something
to
like
notify the secretary of the board.
Right. I mean, I agree with you. I mean, we as the board members and the administration
expect to
should
be.
just expect that people are, if not taking, exact notes, we should just expect that. But as you said, if we have a committee meeting that's not being taped and someone comes up to say something and someone in the audience is taping it, then
I mean,
they're not gonna edit out the
It also does bring up the
inappropriate-
issue, which is what we had recently, where somebody at a public comment revealed confidential information about their child.
and we can't edit that out for them.
We can't edit that out if it's somebody in the public making the thing. So I guess that would be,
I don't know how to do it.
No, but I'm just saying, I guess it would be a courtesy to
Or-
other citizens to know they were being,
Or, as you already put on your board meeting, a statement that the meetings are being recorded. You could also put a statement on there saying, members of the public are advised that other members of the public may be recording the meeting and should act accordingly. So why don't we,
Yeah, I mean,
Okay.
that works for me.
all right, I'll say it that way.
And
Agenda will note that.
And I don't know if perhaps for the first several meetings or so, we make sure that we state that as well.
Okay.
I don't know.
I'll add that language then.
Any other questions?
I looked at the thing on the website that said 8:30 to 9:30 and said, no way. And it looks like we might just be able to do it.
I'll have to let Dr. Kelly know that this is a much more efficiently run meeting. But I would add that the future discussion items have ties to curriculum, so I'll make sure that I'm connecting with Dr. Marseille and as we work through those next few policies as well, so.
Okay, and we need to open up to audience recognition. So if there's any comments, can you come and sign in?
Hi, my name is Francie McComb from Bell.
I don't think the mic is on.
Oh, well, can the 4 people in the audience hear me?
There you go.
Okay, well, I think it's wonderful it's being taped, and I think you guys are going through a lot of machinations to avoid doing the obvious thing, which is tape every meeting. Tape every policy meeting. I'd like to see this come on the agenda or at a future meeting at night where people can see whether or not we're really committed to transparency. You guys are suggesting policy changes here. That's appropriate. I've heard Dr. McGinley at the Federation of Civics saying it could be done. He didn't say you would do it. People on this board, every one of you actually ran under the theory that we're going to bring more transparency. It was in every one of your campaign materials. So I would like to see that done. Policy meetings clearly everybody should be knowing this is going on. Whatever you're doing, it's important. And I'd like to see that happen. Second of all, with respect to the coaches' policies, there was an incident on a team that 2 of my kids participated in last year. Because of the change of policy, it was very unclear to the coaches what to do about it. And I'm firmly support the district in taking very strict things. There's spirit dinners the night before almost every sporting event. Is that a school district event? Is it not? Does it matter if the coaches are there, if it's not? I don't think it's clear. And I think you guys need to think about how this is being received and so that the coaches can tell the kids, we're going to do this, and then do it. And I don't think that's the situation right now. It certainly wasn't last spring. And it's really very important, I think, for the kids. I understand the New Jersey law. I've read it. The last thing is, there is a debate going on right now on Facebook about the ceremonies that we did yesterday. This isn't a policy issue, but I encourage the school district members who want to know about how it went at Lower Merion yesterday to go on the Lower Merion Community Network and sort of see what the kids are saying about it, because I'm a little bit upset about what I read, and wasn't my child who posted it, but I think we should be concerned about how what we do is perceived by the kids. Thank you.
Okay, is there any other comment?
Francie, can you walk me through how I would do that? I'm not a big Facebook person.
If you give me your email, I can email it to you. Anybody who wants it.
Okay, I think we're adjourned, and our next policy meeting is, I don't remember. The 11th, I think? Yeah,
Oh, October 11th. Is it a Tuesday? No, it's
it
a
should
Friday.
be a Friday.
Friday, that's right, it's Friday, it's curriculum, it's Tuesdays, right?
Right, and it's
At
the same week.
8:30.
Yes.
It's 8:30.
Okay, thank you, we stand adjourned.